Welcome, everybody, to the third of a six-part series on human rights and environmental due diligence in public procurement. This is a series that is organized by Electronics Watch, IndustriALL, the Fair Trade Advocacy Office, and Rethinking Value Chains, with the financial support of the Charles Leopold Mayer Foundation for the Progress of Humankind. My name is Björn Claesson. I'm director of Electronics Watch. So Electronics Watch is an independent monitoring organization for public buyers, focusing on labor rights and occupational health and safety in electronics supply chains. I will be co-moderating today's session with Elena Lunder of the Fair Trade Advocacy Office. And before we get started, we have, as usual, a few technical points for you. Today's presenters and audience are multilingual. So if you need interpretation, click on the globe symbol at the bottom of your screen and choose either French, Spanish, or English. If you happen to have any technical problems, then please find Martina Hooper in the chat and send her a message. And then just a reminder that this session is being recorded and it will be available on the Electronics Watch website after this event. So each session of this series focuses on a building block of due diligence. The first one addressed transparency in supply chains. The next one focused on verification, how to measure and verify effective due diligence from a public procurement standpoint. And today the topic is enforcement, how to enforce due diligence in supply chains. And then the next one, which we will be advertising at the end, will be about the right to effective remedy within the due diligence framework. Today's topic is perhaps particularly challenging in public procurement. When due diligence is mandatory, it also must be enforceable. And so this, of course, raises two questions. First, what is the bottom line for due diligence? Or what is that line that would trigger contract enforcement in a public procurement context? And secondly, if that line is exceeded, if contract enforcement is triggered, what are actually the appropriate mechanisms of enforcement, and how should a public buyer implement them? We have, fortunately, a really inspiring group of experts from public procurement, from civil society and trade unions to shed light on these questions, and you will meet them very shortly. We're also very happy that Heidi Hautala will be joining us again today. Ms. Hautala is a member of the European Parliament and she is a chair of the Parliament Working Group on Responsible Business Conduct. She will be the first one of our speakers and give us an update on the proposal for an EU directive on corporate sustainability due diligence. After Ms. Hautala, we will ask each one of our panelists a couple of questions. And then they will have the opportunity to talk to each other, to ask each other some questions, and then we will go to questions and comments from you, the audience members. But we would encourage you already now to put your any questions that occur to you in the chat. Again, direct them to Martina Hooper, and then at the end she will be selecting questions and reading them. So with that, I'd like to turn it over to my co-moderator today, Elena Lunder from the Fair Trade Advocacy Office.
Thank you. I will not say much because you've already summarized the introduction really well. So yeah, I would just directly give the word to Heidi Hautala to say a few words about the recent legislative proposal presented by the Commission and its connection to public procurement. Thank you.
Thank you. Thank you very much. It's always a pleasure to interact with the organizers of this this webinar. And obviously, the date 23rd of February was an important day I don't need to say that it was one day before the Russian aggression against Ukraine, but nevertheless, the Commission finally came up with their legislative proposal on what they now call Directive on Corporate Sustainability Due Diligence. So there's a new acronym around CSDDD. That's how we call it. I'm still learning. Because as you remember, the first idea was to call it sustainable corporate governance and due diligence and accountability. So, but obviously the Commission did not touch very much directors' duties because that proved to be a little too sensitive and could have delayed the due diligence part severely. So here we are, the European Parliament and the Council are both now already looking into the Commission's proposal. From the Parliament, I can tell you that up to 12 or 13 different committees of the Parliament want to draft an opinion. So you see, never before has there been such an interest. Even during the early stages when the Parliament adopted its own initiative report in March last year, the interest was definitely more vague. And I think the whole civil society, the corporate world, the constructive, progressive businesses have very much attached attention to this proposal. So we have had years and years of companies' voluntary responsibility and sustainability statements. But we also have seen that a growing number of EU member states, but also countries like Norway, a very close ally through the internal market to the EU, have adopted their national legislations. So I would say that meanwhile, the need and wish to have a European-wide legislation has grown because if you think of the company perspective, it's clear that it's better to have the same rules in all EU member states and affiliated states. So the level playing field, I think, has now been introduced with this proposal. So this kind of EU initiative, it's not actually first of its kind because we, as you know, we have the conflict mineral regulation, we have the timber regulation, we have the IUU fisheries regulation, which have certain due diligence element in it, but never before have we seen a horizontal proposal covering all sectors. So I think we anticipated a horizontal proposal. What can I say about the proposal? The overall aim is to put in place an effective due diligence duty for companies to address negative human rights and environmental impacts. First of all, I want to mention that the proposal includes many positive elements, which were also welcomed by quite a number of stakeholders at the time of the adoption of the Commission's proposal. Most importantly, it does encompass the entire value chain, and this had been very much disputed. And for instance, in the German national law, this is not the case. It does not touch the whole value chain, but just the first 3 tiers. And this proposal also has clear liability provisions. Also, that was disputed, that how should the civil liability be introduced into the proposal. So I think this is a strong signal to the global market, and I take it for granted that this proposal, when it will be adopted, it will have impact beyond the EU's borders. So possibly this is an important milestone on the way towards global rules. So having said that there are positive elements, I have to say that this large stakeholder community that has hooked their eyes already since some point on this proposal did not waste time to identify weaknesses, because there are weaknesses that we all want to remedy together. We have to correct certain elements, and I think I also have to say that I don't think that the Commission will be very much surprised, because there's been such a lively interaction. So The main thing for me and many others would be that the text implies that companies could fulfill their obligations by contractual terms with suppliers and offloading the verification process to third parties. Even though these both are relevant elements in due diligence, it seems to me that they are far from being enough for effectively preventing and assessing human rights violations. This approach based on the contractual terms is closer to a tick box exercise, which we never wanted to have, than achieving genuine impact for the people and the planet. Compliance with due diligence obligations could be better reached through putting emphasis on the role of the company board in actively overseeing their due diligence processes. I want to speak about stakeholder engagement, because that has also been disputed. How should companies be obliged to talk to their stakeholders, and how? And many of us have been speaking about the need to have a meaningful engagement with stakeholders. And I do think that this may be one of the most challenging aspects to translate into a legally binding duty. There are good hooks in the proposal on engagement with affected stakeholders, but the role and weight is not enough compared to stakeholders' importance to successful due diligence. I have always had trouble to understand why some companies are so reluctant to put in place what we could call meaningful engagement with stakeholders, because that's a primary source of information about the issues in the supply chain, in all its human rights, labor rights, environmental dimensions. So this has to be looked at very carefully. So the draft proposal, let's call the Commission's proposal, does not give a full satisfaction to meaningful engagement with stakeholders. So we need to look at that all together. And I know that you are representing many important stakeholders, and certainly you will be instrumental in looking into this. So the third question, apart from the problem of the contract-based approach and insufficient engagement with affected stakeholders, I want to mention is the scope of companies covered by the duty of due diligence. SMEs are excluded, and however, I'm aware of quite a number of SMEs who feel that the exclusion is only going to cause problems, because they are often suppliers or partners in supply chains of bigger companies. And obviously, when the legal obligations fall on the shoulders of the bigger companies, they also expect that their suppliers fulfill the same requirements. So this will not be easy to solve, because many SMEs still are afraid of what they call administrative burden and perhaps other issues that could harm their businesses. So let's see what can be done with this. Now, this session that you are having in your series is about enforcement. So as perhaps expected, and which is very welcome, the proposal has two dimensions on enforcement. First of all, administrative sanctions. Member states are supposed to designate national administrative authorities that can impose administrative sanctions, such as fines or compliance orders. And the Commission is about to set up a European network of supervisory authorities that will ensure consistency. I think this approach could be workable, but certainly the Commission needs to coordinate this. Then the second, and perhaps the more important and more crucial element of enforcement, is the civil liability. So the civil liability clause in the proposal ensures that companies can be held liable for harm, and victims will get compensation for damages resulting from the failure to comply with the due diligence obligations, even if the harm has taken place in a non-EU country. And this, I believe, is an important step in terms of the right to remedy for people affected by corporate malpractice or also environmental harm. So I believe that your next session will look more closely into this question of access to remedy. So I don't think I will go too much into that now. So all in all, it's very welcome that this proposal includes both administrative and civil liability. Nevertheless, the civil liability applies to damages caused by companies' own operations, subsidiaries, or established business relations. What is left out, and this I think is important to notice, there is no liability for harms caused by indirect suppliers. So again, an important point which we have to try to improve together. So there's only one limitation. The liability for harms caused by indirect suppliers can be applied if it can be proved assumably by the victims. So again, not easy, I think. So this might create an undesirable situation where European companies might design their supply chains in a way that guarantees them constant change in their business relationships in order to avoid liability. And this is obviously something that nobody wants. This would not be good for people working in the companies. It would not be good for genuine due diligence. Now, I'm very aware that many of you are dealing with public procurement, and I regret that the final version of the Commission's proposal does not include due diligence in public procurement, as we had seen in one of the earlier drafts. I had the honor to host Commissioner Reinders in a public webinar on corporate sustainable due diligence proposal organized by our European Parliament's Working Group on Responsible Business Conduct, known to many of you. I asked about this, and Commissioner Reinders mentioned himself that public procurement was dropped from the proposal because the EU directive on public procurement will be renewed in the near future. So in this regard, the next step would be to ensure that the new EU public procurement law includes all the crucial elements for ambitious and effective due diligence. So I think this is the trend. This, I think, is the next level where we will head together. And I'm very excited that I have heard experiences and views on this topic from, for instance, about a Swedish Public Procurement Act. And I hope that I can myself be more enlightened about what's happening in Sweden, because it seems to me that this will go far beyond in terms of due diligence processes compared to the EU Directive on Public Directive, which we now have enforced, which was adopted in 2014. But indeed, there are many ideas, many thoughts about how the 2014 EU Directive on Public Procurement should be amended. And I count on a good cooperation with all of you when the time comes to do that. And we're certainly ready in the European Parliament. I don't think that we can necessarily incorporate all that work now into the Commission's proposal on corporate sustainability due diligence directive, but certainly countries like Sweden are showing the way forward, and which will be very much, I think, paid attention to by other EU member states and the EU as a whole. So I leave it to this, and I'm happy to listen to other presentations and sort of get more insight about what the work ahead of all of us in the coming months will be. So thank you very much.
Thank you so much, Heidi, for that very useful analysis of the pending directive and for your leadership on this issue. We're actually going to switch speaker orders. I'm saying this to the panelists right now. So Kathleen, we're going to go first to you. And so on the note that you ended on, Heidi, we're turning to actually a presenter from Sweden, and we're going to address the topic of public procurement directly. Kathleen McCoy, welcome. And Kathleen is the manager for sustainable supply chains with the Stockholm region. and she is also a member of the Board of Trustees of Electronics Watch. So welcome, Kathleen.
Thank you.
Yeah. So as we just heard Ms. Hautala say, the Corporate Sustainability Due Diligence Directive, I forgot the term correct right now, does not actually address, does what?
CSDDD.
Okay.
I think.
Well, let's use a full name. This pending directive does not yet include public procurement, even though the revised European Public Procurement Directive might indeed do that. But at the same time, the Swedish regions and other public buyers in Sweden are still looking to adapt your tender and contractual requirements to this new regime of human rights and environmental due diligence, as articulated, for example, not just in this pending legislation, but also in the OECD and UN guidance on human rights due diligence. So can you tell us a little bit about why you're doing this and how you think that public procurement requirements will change as a result of this adaptation to this new human rights due diligence regime?
Thank you, Björn. I mean, we've gradually been attempting to mirror international standards for a number of years. Our present contractual terms refer to the United Nations Guiding Principle on Business and Human Rights, and we change or adapt our contractual terms about every 4 years. So we've always had an ambition to follow international standards when it comes to due diligence, regardless of it being mandatory in legislation or not. But when the Parliament presented its proposal last March, it became obvious to us that we needed to make more significant changes because it was more far-reaching than what we had done previously. So there's a draft circulating right now. This is a draft that a national authority for public procurement is working on together with representatives from our region and the municipalities procurement body and lots of stakeholders as well. And a draft will be circulated externally as well. But if I just address the main changes, we've added more with respect to due diligence when it comes to the environment. So that's been updated. Before we referred to national laws, now we include the climate and so more fleshed out on the environment part. We've added the obligation to, and this is a hard one because it's not translated yet, and I was thinking about meaningful engagement. It actually says, if you would translate it word for word, it's consultation with rights holders. So we'll see what that, it's a difficult one in Swedish. But anyways, right holders and a special attention to vulnerable groups. We've added provisions on remedy, which is really important because we've been in situations where we've discovered, for example, forced labor down the supply chains and work together with our suppliers, but realizing that we didn't actually have writings about that in our contract. So that's being added. Then we've added as a zero tolerance breach, which right now are forced labor, child labor, serious environmental harm, and grand corruption. We've added a tax on environmental and human rights defenders. We also have a clause on disclosure. It's a huge challenge for us. When we procure, we usually go through Swedish or other companies that are resellers often. It's the vast majority. And then they have, a head office or sometimes an agent. So we're far removed, and even our suppliers are far removed from the chain. And now we've put in our clauses that we want to know the country of manufacturer, the main manufacturing, basically production facilities, so that we have that information, so that we can act upon the risks. So that's in the, and finally, there's a clause on conflict minerals that can be, of course, removed if we're procuring food. But everything where there's a risk for conflict minerals, for example, IT or medical equipment, then there's a clause on that. And then the last thing I just want to say is that we're being more explicit, more clear towards our suppliers on what we expect them to do. So a concrete example is that we've been asking them for years to do a risk analysis in the supply chain, but many of them don't understand what that means, and they'll just assess tier one, their direct suppliers, and stop there, and not realizing that we're actually asking them to be knowledgeable about what the risks are all the way through to raw materials.
Mm. Great. Yeah, your last point about being explicit, being clear, being directive, I think it's very important in order to ensure the compliance. Now, so you mentioned due diligence requirements with respect to environmental standards. You mentioned consultation with right holders. You mentioned a broader scope of remedy, zero tolerance for attacks on human rights defenders, disclosure. So if you can imagine now a scenario where a supplier fails in one of these respects, they basically fail to exercise effective due diligence, what would you do? And how would you enforce any contractual requirements on due diligence?
It's not difficult to imagine because it happens all the time. We routinely audit our suppliers. And since most of our suppliers, like I said, are resellers, what we're looking at is their routines and processes. So a breach of contract, it would be enough that they didn't do a proper risk analysis. Then they're in breach of contract. But our first course of action is always to ask for them to implement an action plan. We work for improvements together with them. Then if either they fail to cooperate or are not improving, then we have the possibility to terminate the contract. Then, of course, there are instances where we procure further down, so from manufacturers. And we've even discovered, because we've, either through information, through partners or media or NGOs or monitoring partners, or because we've done our own factory audits, then we've discovered non-compliances that really affect, the workers. And then, but it's the same course of action. It's first course of action is for the non-compliances to be addressed, and then termination of contract is last course of action. In practice, there are challenges. So if you discover something, where workers are being affected in a negative way, you ask for this to be addressed, then you have to verify that it actually has been addressed. And going back and verifying that is, of course, obvious, but during the pandemic, this was very difficult for us to do. So to require proof that things have actually been fixed and put right is a challenge. And then the second challenge, which is a real one, is if it's a sector-wide risk. So if you take a country like Malaysia that has lots of risks of recruitment fees and it affects a sector, if you terminate your contract with your supplier, you will have to procure those. We procure for healthcare. It's not like we're not going to buy these things anymore. We need to purchase them. Who are you going to go to instead? And how do you know that it's better there? So in practice, these are challenges that we try to deal with.
Yeah, great. And these are great questions for discussion. And I would just encourage fellow panelists to listen to these questions, and maybe you can address them when it's your turn to speak. The final thing I wanted to ask you is if you had a wish list for the directive that is being developed right now, the corporate the sustainability due diligence directive, what is the top two, three things on your wish list? What would really help you to support you to do your work in Stockholm region and to ensure that suppliers exercise effective due diligence?
Well, I mean, if the Parliament's proposal had gone through, then that would have been an improvement. I mean, the fact that it's mandatory is positive, of course. I agree with that. I think that there are problems with the scope. The majority of our suppliers are not the large corporations. They are the smaller ones. And also even within the smaller scope, which is 250 employees, what's defined as a risk sector is only the risk sectors where the OECD has provided guidance, which means that the IT industry isn't included in the smaller corporations, which is, quite surprising since the IT industry has huge risks. So, and also that if they would have stuck to the to the international standards that we already have. We already have the United Nations Guiding Principles. We have the OECD guidelines. Why is the Commission introducing new terminology? I think it's muddying the waters. So a wider scope, basically sticking to the international standards that we have. I think that those are two things that would make it easier for us. Because if it's mandatory, then it's not just the sustainability departments that we're dealing with, and the legal departments have to get in from these corporations. It becomes a compliance issue. They have to channel this through the sourcing departments. It becomes a completely different ballgame, even for us when we're trying to enforce this.
Great. Thank you so much, Kathleen. Thank you for insightful and concise replies. That's very much appreciated. I think we're going to go back to the first speaker right now, Elena, is Ben van Peperstraat available right now, do you think?
Sorry, he would come at the end, so after.
At the end, okay. So then we will continue now. We're going to, in a slightly different order than planned, but Gemma Friedman, are you, you're there, I see you.
I'm here and ready.
Great. So Gemma Friedman is International Officer with the Public Sector Union Unison in the UK. And she also is a member of the Board of Trustees of Electronics Watch. So thank you so much for joining us, Gemma.
Thank you.
So for you, this is a very timely topic, I believe. You're working on the sort of a British due diligence legislation campaign for, hopefully I get this right now, the Business, Human Rights and Environment Act. And as I understand, this legislation will include public buyers as integral supply chain actors. So that means that public buyers themselves will have some due diligence responsibilities, right? Can you describe what those responsibilities should be from the Unison perspective?
Yeah, thanks a lot, Bjorn. Absolutely, we are campaigning for that in the UK. And Principle 8 of our short legal principles, which you can find on Corporate Justice Coalition's website, includes a section that says it includes public sector bodies, including those using public procurement and other public bodies providing financial and other support to businesses, such as export credit agencies and development finance institutions. So we go a bit broader than just public procurement as well. We understand that we are the only national or other campaign to call for such an inclusion. And we at Unison are developing the content for this to work through with our coalition partners. And it makes sense because our members at Unison are actually public procurers across a wide range of public procurement functions in the UK. And perhaps it's because we're now out of the EU and we also have our own new Public Procurement Act that is set to be tabled in the UK, that we need to be able to take this stance. And of course, the Modern Slavery Act, they've already said, the government, that they would include the public sector when they have time. It's been, I think, over a year since they said that, and it hasn't happened yet. So just to be clear, our position is not finalised. We're still writing it, and we are working with barristers to ensure that it fits into our public sector framework properly. And we'll be developing and releasing legal opinions, etc., to help on specific case studies to help with that. But one other thing before I go on further is to say that we don't just want it to cover products. We're also testing to see whether it can cover services, because human rights and environmental abuses occur in the delivery of services too. And in fact, it's our members as well as the public who can often who are at the hard end of that. So before I go into the procedural, to directly answer exactly what you said, I just want to say that we are really aware of how ambitious the scale of what we're asking for is. But the private sector itself is, publicly says that they want, as Kathleen has referred, clear, unambiguous standards to be had, and it is for the government to set that. It will take a large amount of funding to really make this kind of thing happen. But I would put an analogy with that it's no different from investing in, for example, the prevention of cancer, where it takes less resources to resolve to prevent the disease than it does to cure it and cure a person back to full health. So procedurally, the types of responsibilities, and I won't go into them because Kathleen and others who are leading in this include, and also our own Whitehall departmental modern slavery reports and guidelines very well set out a lot of how to do this properly. So I won't go into that because there is good practice out there, but we would probably go a little bit further in some things. So we would, for example, talk about having the need for, and it's great to see in Sweden that you're talking about having human rights defenders put on that list, but we would also talk about having, you know, favouring independent democratic trade union recognition and collective bargaining agreements, or at least genuinely working towards that in a very verifiable way. We'd also look at worker-driven monitoring, which we believe that Electronics Watch really leads the way and the standard of, as well as joint audits with trade unions. We'd also look at national grievance mechanisms for reporting or indeed devolved grievance mechanisms where there are devolved governments, and investigation mechanisms, as well as full transparency so that those meeting the criteria can be, as far as, I mean, there's never going to be an easy or perfect way to do this. For those that do meet the criteria, they ought to be, it ought to be out there. And those that don't, it ought to be out there again. The details of, you know, publicly, including the risks. The government could make it much easier for everybody to know what's going on where. And we've really got to get into a position of full transparency now for that to happen. Finally, when it when it comes to resourcing and effectiveness of the work, contract measures are not enough. And so we think that one of the key reasons it must be mandated is so that, for example, in the UK, there are more than 4 government departments that have got a role to play in this, including those that are involved in aid and development, for example. And so we really want this to drive a strategically joined up government to ensure that the work is fully funded and that it's effective and efficient and always growing. You're on mute.
Sorry. Thank you, Gemma, for that overview. It sounds like, perhaps you will be creating a model for the rest of the other countries here. I wanted to return to a question or to an issue that Ms. Hautala raised that maybe you can address, and that is, and you touched upon it, and that is the importance of meaningful stakeholder engagement. If you can talk about that from the perspective of a trade union, I imagine you would emphasize the vital role of rights holders, workers, and their representatives in the due diligence process. How do you envision this? Do you have you developed the concept of this in the campaign?
So, I mean, these things are always being further developed and further refined. Before I go specifically into that, I just want to touch upon the role of trade unions, because I think it is important. And
I'm sorry, Gemma, we should
time-wise,
keep
okay,
to 2 minutes.
Okay.
Yeah.
So trade unions as both those that protect and promote the rights of workers, but also they are the victims as the human rights defenders, and in their very legitimate role. I think that we would, sorry, I've been unwell, so I have a foggy brain, so I've just got a few notes to hand here. We would, I've already mentioned the joint monitoring that can take place and the joint grievance mechanisms. We would also devise plans for investigation and verification jointly negotiated agreements on the decision of outcomes of investigation, and also on the negotiation of the remedy in full, not just talking about money, but also about the conditions in the workplace, the union busting that happens all over the world all the time. and all of this it's all doable. There are examples where this happens. We all know about Rana Plaza. There is also the Tomato Pickers Agreement, and there are some global and regional development banks which have got some good practice. So it's all very well done. The only other thing I'd like to say is there is a role, of course, for the employers' organizations as well. But I just want to emphasize that in terms of their legitimacy, how legitimate are they to be involved in this if they refuse to sit around the table with bona fide, legitimate, free, democratic trade unions, or indeed have their own ethical standards which undermine the International Labour Organization standards? So I would pose a challenge there to any lawmakers to really think that part through.
Great. Yeah, we do have a lot to learn about exactly what does meaningful stakeholder engagement mean and how do we operationalize that within the public procurement process, for example. Thank you so very much, Gemma. We'll come back to your questions, I'm sure, during discussion. I'd like to now go to Victor Torrents. And Victor Torrents is the head of contract monitoring for the Association of Catalan Municipalities, of course, in Catalonia, in Spain. And welcome, Victor. Thank you for being with us today.
Hola, buenos días y buenas tardes. Bueno, encantado de estar aquí con todos ustedes y vamos a proceder pues a presentar lo que hacemos desde la ACM.
Okay, so I have a couple of questions for you as well. And the first question is a quite general one, because of course there are provisions for enforcement of contracts in any contract that you set up. And I was wondering if you can just start by talking about how in general is a public contract in that you would be administering enforced. If you can educate us a little bit about those mechanisms that are available to you.
Bueno, nosotros como Asociación Catalana de Municipios trabajamos con la figura del acuerdo marco, con lo cual nosotros establecemos licitaciones públicas que los beneficiarios de las mismas son las entidades locales que son nuestros socios. Entonces el acuerdo marco tiene algunas particularidades, también la verdad que tiene una gran fuerza de poder dar a conocer todas estas cláusulas que podamos incluir en nuestros contratos, porque la utilidad pues viene multiplicada por cada una de aquellas entidades que se adhieren. Nosotros en estos momentos tenemos 1000 socios y nuestros beneficiarios son unas 2000 entidades locales o dependientes de entidades locales de Cataluña. Claro, nosotros en nuestros acuerdos marcos estamos trabajando todas estas cuestiones con lo que llamamos las condiciones especiales de ejecución. Nosotros hemos trabajado condiciones especiales de ejecución medioambientales, por ejemplo, puede ser la de que tenemos 900 entidades catalanas suscritas al acuerdo marco de la electricidad y con lo cual allí desde hace ya más de 8 años están suministrando energía verde a través de una condición especial de ejecución. Pero también tenemos, y el motivo del que hoy estamos más hablando, pues también condiciones especiales de ejecución para el cumplimiento de los derechos laborales. En este sentido, pues estamos trabajando, introduciendo pues, la necesidad o la obligación de que en toda la cadena de producción de aquellas entidades que están proveyendo los productos adjudicados, pues contemplen pues, y cumplan con el Código Básico de la Organización Internacional del Trabajo. A día de hoy, estas cláusulas las estamos incorporando cada una de ellas, ya sean las medioambientales o estas de tipo laboral, pues las estamos incorporando en cada uno de aquellos acuerdos marco que tienen mayor adecuación. En el caso de temas de organización del trabajo, las estamos incorporando en el acuerdo marco de equipos de impresoras y multifunción y en los equipos informáticos. A partir de aquí, nosotros a día de hoy, pues hay unas 500 de estas entidades que están contratando equipos informáticos o impresoras con esta cláusula, digásemos, con esta condición especial de ejecución que han de cumplir con este código básico. No sé, ¿qué nos permite y qué no nos permite esta condición especial de ejecución? Claro, la condición especial de ejecución nos lleva directamente a, cuando no hay el cumplimiento, a poder ejecutar penalidades. Y así nosotros las tenemos estipuladas en nuestro pliego de condiciones. Podríamos, en algún momento, podríamos pensar en otra fórmula, que más la contemplamos más en un futuro, que es transformar estas condiciones especiales de ejecución en una obligación esencial, y con lo cual un incumplimiento de esta obligación esencial del contrato podría conllevar a resolver el contrato en sí. En este momento, la condición especial de ejecución que aplicamos lo que nos lleva es a penalidades. ¿Cuál es el montante de estas penalidades? ¿Qué es lo que acaba siendo, qué es lo que repercute sobre la empresa? En estos momentos, no cumplir con la condición especial de ejecución se contempla en nuestro pliego como falta grave y puede ser penalizada hasta un 4% del valor del contrato. No es por aquí, en estos momentos, donde estamos ejerciendo la máxima fuerza, porque nosotros, como comentaba algún compañera anterior, pues estamos trabajando muchas veces con empresas que no son realmente el propietario de por ejemplo, la fábrica o la cadena de producción, sino que estamos trabajando con distribuidores, con lo cual tenemos que trabajar ahí con doble medida. En estos momentos, ya digo, estamos trabajando con estas cláusulas, pero por ser un acuerdo marco nuestra modalidad, nos permite tener un instrumento que quizás cada uno individualmente no dispondríamos, que es que el acuerdo marco firmamos nosotros contratos con las empresas adjudicatarias para un máximo de 4 años. Normalmente el contrato es de 1 año más 3 posibles prórrogas de 1 año más, o 2 años más 2 posibles prórrogas de 1 año. Con lo cual, en estos momentos, si incumple, tenemos otro instrumento a añadir, que es no prorrogar el contrato, que es una fórmula mucho más, digásemos, factible, sencilla y limpia de poder ejecutar cuando tú no estás contento o ves que no están cumpliendo con aquellas actividades. Quería hacer esta apreciación porque los acuerdos marco nos da este punto que no hemos utilizado porque, por suerte, de momento estamos en una fase mucho de, digamos, difundir la aplicación de estas cláusulas y dar a conocer entre las empresas adjudicatarias que esta es una tendencia inevitable y que todos queremos. Y si bien siguen, como hemos iniciado hace también 3 años, incluimos esta cláusula, bueno, las empresas no hemos tenido motivo de tener que ni dejar de prorrogar ni aplicar penalizaciones. Si bien ya hemos tenido alguna serie de encuentros y de solicitar mejoras en este sentido. Ya digo, nosotros por nuestra parte vemos el momento actual de la contratación y la inclusión de todo lo que sería la diligencia debida como un momento claro en la oportunidad de difundir todos estos aspectos dentro de la comunidad, digamos, del entorno empresarial, y esto lo hacemos a través de la contratación pública y sobre todo a través de todo lo que sería nuestras consultas preliminares de mercado. Nosotros, antes de abordar cualquier licitación, abrimos un periodo de consultas preliminares de mercado donde les preguntamos qué queremos y qué pretendemos de esta licitación y si el mercado está dispuesto a proveerlo. Esto nos permite que ya desde el inicio estemos planteando todas estas cuestiones y con lo cual dar a conocer mucho más en un entorno propiamente más local de Cataluña, que es nuestro ámbito, pero bueno, nuestra Nuestra intención es ir difundiendo esto porque adquirir fuerza, ganar fuerza, para a través de esta fuerza pues ir haciendo tendencias, y esta fuerza no únicamente desde una posición de Barcelona, sino una fuerza que es la que poco se representa en la reunión que estamos hoy. A mí, personalmente, Bjorn, lo sabes, hemos tenido que contactar con, ya no únicamente con el distribuidor, sino también con el fabricante final, indicándole pues bueno, que debía de mejorar en algún sentido, indicándole las disfunciones que habíamos encontrado, y para nosotros fue muy, bueno, fue muy importante que cuando nos dirigimos a estas empresas, si bien la carta la enviábamos nosotros, podíamos decir que en la misma situación estábamos nosotros como estaban entidades de Suecia o entidades de Inglaterra que estaban yendo a comprar los mismos equipos en la misma fábrica. Con lo cual te da una sensación pues de, bueno, sensación, no, una realidad de que estás empujando y empujas más de lo que puedes empujar desde Barcelona con muchas entidades fuera, porque en estos momentos tenemos 500 entidades que están comprando con esta cláusula, pero bueno, tenemos la fuerza que tenemos desde Barcelona, la que podemos tener desde Cataluña, ¿no? Con lo cual, bueno, un poco este es el escenario en el que nos encontramos actualmente. No sé si querías profundizar en algún otro aspecto o querías que, ya digo, en este sentido nosotros nuestra idea es...
Thank you very much, Victor. We do need to go on to the next speaker. I think thank you very much for illuminating your situation. I think I heard that you're emphasizing the value of consultations, both before a contract has been awarded and also potentially after it's been awarded, to address possible infractions in the supply chains, to ask for improvement plans. But then also you mentioned the possibility of enforcement in the form of, I think you said, penalties amounting to 4% of the contract in serious situations, I suppose, and even the option then not to renew a contract if a company is actually failing to address situations in their supply chain. So thank you. That is very helpful. And now I think we do need to move on to the final two speakers. So I will now turn it over to Elena, I think.
Yes, thank you. And I will move to Joseph Wild from SOMO, who is joining us today to speak about the concept of responsible disengagement in the context of enforcing due diligence. So first, could you say why it is important to talk about responsible disengagement in this conversation, and briefly, what are the essential elements?
Yeah, thanks so much, Elena and Bjorn, and good afternoon or morning or evening to everyone. Yeah, I'm really happy about this question about responsible disengagement in the context of due diligence. This is something that I and SOMO have been thinking about and writing about for a while. And for me, it really is, it has so many elements of where the rubber hits the road when it comes to due diligence, like where the due diligence rubber hits the human rights road, whether this due diligence legislation is really going to have a positive impact on people, or whether it's going to leave people out and the victims out in the cold. So I think this is a really important element to be discussing. Heidi mentioned at the top in her keynote speech this need to avoid the tick boxes form or practice of due diligence. And in fact, I published a paper earlier this year along with Ben, the next speaker, and a few others, in which we entitled Respecting Rights or Ticking Boxes. And really, we looked in at 12 crucial elements of due diligence, concepts of due diligence, that it is really important that legislators get right in designing due diligence legislation. And one of those elements is responsible disengagement. And so just to run briefly through a couple of the elements of responsible disengagement for those of you who might not be familiar with it. And the sort of ironic thing I always start out with is responsible disengagement is really more about engagement and being a responsible buyer and being a responsible business partner than it actually is about disengagement. So responsible disengagement really all starts with the initial selecting the business relationship status and with setting clear standards and criteria for when you enter into a business relationship. And I think this is important also in the context of the public procurement debate that we're having here. But it's important to have clear standards up front and out there when you select a business partner, when you enter a business relationship, and to have a clear responsible exit policy already in place. In this way, you can front load leverage because, as we know, many times that companies get into a business relationship, or public procurers even get into a business relationship, and once you've signed a contract and the relationship has started, leverage dynamics change, and a lot of times you lose leverage. So front loading that leverage is really important in the selection criteria and in selecting the business relationship. And then the next stage of responsible disengagement, again, is more about engagement. It's about being a responsible business partner and a responsible buyer. It's about establishing strong and meaningful relationships that are built for the long term. And the due diligence, the positive due diligence element. I mean, a lot of times I think we think about due diligence as sort of reactive or reacting to negative or impacts in the supply chain. But the positive element of engagement and supporting your business partners, providing resources, providing training as a buyer, as a procurer, is also really important in due diligence. And that is equally as when a problem does occur. And so if a human rights impact does show up, that you provide the support and you provide resources to your business relationship to assist that business relationship in addressing the issue. And really, again, important at this stage is that cutting and running aspect of, oh, there's a problem there with our business relationship. We're just going to end this relationship and move on as quickly as possible and leave the problem there. I think this is really crucial here. That due diligence is, again, it's about being a responsible buyer and supporting the business relationship. And again, many of these things, I think Kathleen mentioned that earlier too, these are due diligence concepts that are already in the OECD guidelines, for example, and already in the UN guiding principles. So I think it's important for the legislation to follow those standards that are already there. Then back to responsible disengagement elements just for a minute. If a company does decide that disengagement is necessary for different reasons, if there's no progress on it, there's no possibility that the impact is going to be mitigated or remediated, it's really important as part of responsible disengagement that the company mitigate the negative impacts associated with the disengagement itself, impacts on workers, impacts on communities, and particularly thinking about the gendered impacts, so the additional or different impacts that might be on women workers in supply chains, and that the disengaging company itself, so the buyer, the purchaser, it also has a responsibility, again, under the OECD guidelines and the UNGPs to mitigate those negative impacts. And the Bangladesh Accord, I think, is a good example here of where that happens. And Ben will talk about that in just a minute. And then, of course, providing a possibility for re-engagement. Once disengagement does happen, providing the conditions, this brings it back to the beginning. Again, providing the conditions and the criteria for re-engagement and allowing the business partner a possibility and a chance to come back and to re-enter, and giving them a positive incentive to address the impact. And again, this is the opposite really of that cutting and running type of engagement, where it's sort of the tick box and we've checked, oh, there's something there, we're going to move on and go away. So this is really the positive aspect. And then finally, the meaningful stakeholder engagement throughout the entire process of responsible engagement and responsible disengagement, making sure that you are in touch, you are meaningfully consulting the workers, you are meaningfully consulted unions and communities and other civil society groups that are there, is really sort of crucial to this responsible disengagement element.
Thank you so much for this comprehensive overview. Really, making sure that while we're talking about enforcement measures, we also keep in mind that these measures should also be designed with the rights holders in mind, and that a complex process should be considered.
And then also thinking about this in the sense that responsible disengagement, I think, can also really help us address some of the more structural issues in supply chains. If you talk about in these big sort of thorny problems of child labor and living wage that really require a lot of different actors to get involved, and not just, it's, a lot of times companies let's think of due diligence as just addressing a single issue or a single problem at a single supplier and how to deal with that. But this element of responsible engagement and avoiding irresponsible disengagement, I think, can really help motivate a larger group of actors and companies to address some of these thornier issues. And then just to bring it back briefly to the topic of this seminar here on enforcement, and looking at the Commission's proposal now that Heidi talked about at the beginning, I think we talked about in that publication that we had about how to avoid or how to get right these 12 important concepts of due diligence, and responsible disengagement is one of those 12. And unfortunately, I think the Commission's proposal really gets exactly wrong this aspect of responsible disengagement, and where you see in different types of enforcement mechanisms, the focus on the contracts and everything running through the contractual obligations, the liability focus only on the established business relationships, and basically incentivizing companies almost to engage in this sort of very quick type of business in and out, cut and run business relationships, and pushing the costs down into the supply chain. I think is quite a big challenge now that we are definitely going to have to work on going through. And the fact that the public procurers are not included in the enforcement provisions, I think Björn referred to that earlier as well, is a real miss here, because public procurers, again, as important buyers, as state buyers who can set a real example of this type of responsible engagement and avoiding irresponsible disengagement, I think is crucial. And for them to have the fact that, an exclusion, again, this sort of first step of the responsible disengagement, exclusion of companies who have demonstrated that they will not follow due diligence, or they have had problems, them being excluded from the initial screening of public procurers, I think is a real miss in this in the Commission's proposal, and something that should be addressed. And then just maybe one last word of caution, because I do think we hear sometimes this argument by companies and some governments out there saying that enacting good due diligence legislation is going to negatively impact production countries because it's going to lead to a boycott or this kind of thing. And what I would say there is, if that is happening, you have not designed your due diligence legislation well. You have not understood the real concept of due diligence as it is conceptualized in the OECD guidelines and UN guiding principles, because those two standards, they are all about enabling supply and enabling responsible engagement in the supply chain. And if you're worried about that happening, then you need to sort of, again, go back to this crucial interpretation of the concept of responsible disengagement in the due diligence standards that are there, and make sure that you're getting that right in your legislation, and make sure that your enforcement and your incentives in the legislation are getting that piece right.
Thank you. Yeah, I wanted to ask you also about elements that you addressed anyway already. So I think we can now move to Ben and come back to any questions the other panelists or attendees might have later on in the discussion. So thank you very much for this. And Ben, thank you for joining. So Ben from the it's a long name, European Center for Constitutional and Human Rights. So I would like to ask you to maybe take a step back to look at the due diligence concept in general and the role of enforcement mechanisms and what we saw already in the past, what kind of enforcement mechanisms are essential for effectiveness of due diligence mechanisms, and maybe also, what can we learn from existing good practices? For example, can we learn from the processes behind the Bangladesh Accord?
Yes, thank you very much, Elena, for that kind introduction. And also thank you very much to the organizers for bringing us together for what is a very interesting panel and a very crucial one, also talking on enforcement on public procurement. So as Elena said, I'm a senior legal advisor at the European Center for Constitutional and Human Rights, but in full disclosure, I'm also very happy that I see a lot of my former colleagues when I was working at IndustriALL Global Union, when I was specifically working on the Bangladesh Accord. So it's really great to see so many, well, I wouldn't say familiar faces, but at least familiar names in the Zoom room. And finally, also my apologies to the organizers for being a bit late with a stable connection, because I was on a train that was delayed, but that's happening again nowadays. But then turning indeed to enforcement, because that's, I think, the crux or the key element that we are seeing now that legislators across the world are legalizing, so to speak, human rights due diligence. And Heidi has already referred to that the Commission proposal, the vision of enforcement of the Commission, is basically on two legs. With the one hand, state regulators looking at and for how companies are doing, but also with a possibility for victims or affected people or affected groups who had suffered harm to also go directly to a civil court and also demand enforcement, although that part is much more curative. The challenge when designing enforcement in the context of human rights due diligence is that there is not so much experience around. We do have some due diligence laws, but they're either a bit too new to have been successfely tested. The Norwegian law that also Heidi referred to is only recently adopted. There's not specifically been cases under it. There's also not necessarily been enforcement actions under it. The same with the German law, which is not active law at this moment in time, and where the German government is still manning and structuring its enforcement authority, because the German law is heavily reliant on administrative enforcement, and where the BAFA, the institution that is competent to start checking upon companies whether or not they have lived up to the obligation of the German supply chain law once it is in force, is at this moment a work in progress. So it's also a bit too early to learn there. And even if we then look to the French Loi de Vigilance, which does already have a longer lifespan in place, we are not at a point yet that we see sufficient substantive judgments to really understand how that civil enforcement can look. And that's maybe also a testimony to how slow sometimes judicial processes in general can go. So I think if we then look at enforcement, it is indeed the question is brilliant in then looking, can we look elsewhere on good examples of where enforcement has worked and where it has really driven change. And then indeed, Gemma actually mentioned earlier two agreements, the tomato picking agreement in Florida, but also the Bangladesh Accord are two of those legally binding agreements between labor, so in labor, and in the case of the Bangladesh Accord, trade unions specifically, and companies on performing and managing specific risks. And in the case of the Bangladesh Accord, that specific risk was fire and building safety, which is, as we've all seen almost 9 years ago, can have very little outcomes. And in those agreements, they interiorized the enforcement mechanism. So there was in the Bangladesh Accord, had its own enforcement environment. And that happened at 2 levels. First and foremost, workers, any worker could go to the Bangladesh and a court who had a complaint mechanism where they could lodge any risk related to occupational health and safety. They could say like, okay, I saw a crack in my factory, and then a court would go and investigate. And the brands, the garment brands who were signatory to the accord were then under a legal obligation to tell to their suppliers, their factories that were manufacturing to them, if that complaint mechanism found an issue, crack in the wall, which needs to be fixed, or which is too late to be fixed, or an occupational health and safety committee that was intimidated, or the remit was relatively broad. If there was an issue found, the brands had to go and tell their supplier, you need to cooperate, you need to fix this. And so they had their stick and a carrot. On the one hand, they said like, okay, financing should not be a problem. So we are legally bound under the Bangladesh Accord as brands and retailers sourcing from you to make sure that financing is there in one way or another. But there was also the stick. Like, if you are not implementing these remedial actions quickly enough or robustly enough, and after a few warning shots, because there was a whole escalation strategy in there, we will collectively stop sourcing from you. And so in that sense, there was that threat of disengagement, which Joseph has mentioned earlier, and where in the paper that he mentioned, the 12 commandments, as Politico has called them, in that paper, that thinking on what is a responsible disengagement borrows a lot of that experience of the Bangladesh Accord at that level. So that's when factories are not doing what they're supposed to do. The question then is, what happens if brands are not doing what they are supposed to do, which unfortunately is still a daily reality in the garment and textile sector. So at that moment in time, the Accord also, and still, the Accord has a second level of enforcement, which was an arbitration. So the unions could go to a brand and say, we think you have not lived up to your obligations under the Accord. And if the brand agrees with that, then there's no problem. But if the brand disagrees and said like, no, I did what I was supposed to do, the unions could go to the steering committee of the Accord and submit their claims. And the steering committee, which had 50% unions, 50% brands, would then come to a joint conclusion or not. And if any of the signatories was not happy with it, they could go further. They could go to an independent panel of arbitrators. And that arbitration would then be final and binding for everybody. I think this mechanism hasn't been fully tested. The unions have done quite a number of pre-arbitration actions, telling brands that they were not living up to their obligations under the Accord, which has often led to satisfactory improvements in the brand behavior to manage specifically the risks in their supply chain. But in 2 instances, it really came to that endpoint of arbitration. And even there, at that last moment, the unions and the brands settled. So that settlement is private, but at least it went to the level of arbitration. And I think it's like I'm presenting it a bit formally, but what is very important is that each time that the unions in the history of the Accord launched a new arbitrations or enforcement step, even if it was only to 1 or 2 brands, it had such an impact on the overall rate of actually brands remediating specific risks in their supply chain. Because the Accord was 200 brands. You can't start litigating against 200 brands at the same moment in time, but each time one of them was under enforcement, it did send a message to other brands who were potentially doing an equally slow job of addressing specific risks on fire and building safety, that they could be next in such an enforcement strategy. And those brands, a number of smart brands, then just decided to focus much more on getting actual results in fixing stuff. So the preventative aspect of enforcement, although enforcement is often curing, the preventative aspect should not be underestimated. And I think this is very important when we come to human rights due diligence, that actually prevention is always so much better than the cure. So the same logic then also applies to the EU mandatory human rights due diligence directive once it is finally agreed by all the co-legislators and then transposed into member states, is that these enforcement authorities, as well as individuals who want to press charges against brands, each time they do that, they might also send a signal to the rest of brands and retailers or other companies in the same sector that they might also run that risk. And that is very important to see that dynamic between enforcing and the impact that that has on the behavior of the rest of the economic actors that are covered. I may leave it at this, and I'm happy to answer any further questions if there are.
Thank you again for also these lessons learned that we can. Could it be that the Spanish? Okay. Yeah, so thank you to all the contributions. Since we are a little bit behind, I would skip the panel discussion amongst the panelists and go directly to Q&A. So this is an option for both the participants and also the panelists to raise questions to other panelists. And yeah, in the next 7 to 10 minutes. Please either raise your hand or put your question in the chat.
We do have some questions already in the chat. I've been following them, so perhaps do you want me to go ahead with those? And in the meantime, if anyone has any more questions, feel free to post them in the chat. Okay, so we have a question from Rakesh. Are there plans for leveraging EU's political engagement with policymakers of other countries to get greater alignment and potentially making it a little easier and less expensive for companies with training or audit activities on due diligence in supply chains? I'm not sure if that's to anyone in particular or just to the panel in general.
Sounds like a question potentially from Ms. Hautala. Or to address it.
I think you're on mute, Heidi.
Okay, now, sorry, yeah.
Yes,
yeah,
there we go.
Somehow. May I? Yes, my screen just got somehow stuck. Well, this is a really interesting question because I think the EU should use its leverage with other countries and regions to sort of, first of all, well, I think there's several dimensions. What I can come to think of is that, of course, there's some concern in producing countries, and I'm very aware of the cocoa producing countries, Côte d'Ivoire and Ghana, that they really feel that they should be supported by the EU for their, let's say, efforts to improve the conditions of production in terms of deforestation or child labor. And I think there is quite an awareness among the EU Commission that it has a toolbox to address this kind of issues. Well, basically, it's also classical development cooperation. So I think there is a concern in some of the more sensitive producing countries. And then as I'm dealing with the review of the GSP regulation, we're actually trying to write into it, and I cannot promise to you that we will be successful, but in our preliminary discussions in the European Parliament, which is of course just one legislator by the side of the Council, I'd like to sort of oblige the GSP beneficiary countries to put in place a national action plan on business and human rights, which could be a very good step towards what we would like to see. Some arguments have been said against this proposal is that it's not this sort of UN guiding principles is not a mandatory document, but I think this is not a very good argument against it, because I think we also have to use sort of, let's say, mandatory ways of promoting voluntary mechanisms that could lead into improvement of legislation and real progress on the ground. So these are the things that I come to think of. But then, of course, I think also G7 could be a forum, because, as you know, for some reasons, the US wanted to discuss the forced labor issue within G7. And well, clearly this is geopolitics as well, as you all know. It's the China Uyghur issue, which is a burning issue. But I think also a cooperation with like-minded partner countries, like, well, I'm thinking of Canada, the EU, New Zealand, Australia. I mean, this whole issue of forced labor has been very much on the political agendas, and perhaps we can see some convergence there. And by the way, I forgot to say that in the Parliament we have quite many discussions these days on how the Commission is going to come up with its promise on creating a specific instrument to deal with imports of products, maybe services, produced with forced labor. And there's no clarity at the moment, but the Commission is telling us, especially in the International Trade Committee, that it is coming, something is coming. We don't know what, but that could also, so that the forced labor issue could trigger quite a lot of international cooperation. And I think I saw at one point, I saw that our good friend Andy Hall was on the participants list here. And as we all know, and this was mentioned also by Kathleen, that Malaysia has been so much now under scrutiny on the forced labor, the migrant workers' conditions. So even a country like Malaysia could be sort of uplifted a little bit in terms of how they react to, how they deal with this issue of forced labor. But I don't know what Kathleen thinks about that.
Okay, thank you. So I'll move on to another question from Dimitri. Where is the role for norms for effective monitoring in this? From our perspective, you might find a problem. You might even responsibly pull away, but without consistently effective monitoring, you'll not know if new suppliers represent improvements on the employment conditions of the supplier you pulled away from. Again, that's not directed at anyone in particular, so whoever would like to pick that up.
Should I take that one? It's a little bit about responsible disengagement. Yeah, I think it's a good question, and it goes to that point of if you do pull away, if you do exit, that you keep the relationship open, keep your feelers there, keep the monitoring in place, so that you know and you incentivize good behavior, right? It's not just getting in there, seeing bad behavior, and then immediately leaving and moving on to the next bad, problematic supplier maybe. But it's about incentivizing good behavior. So it's both the initial step of the selection, the initial selection criteria, and making sure that you're engaging, you're doing that due diligence and front loading that leverage in the beginning. And then once you've decided to, maybe you have to terminate a particular relationship, to then monitor it and be sure that there are possibilities for re-engagement, because again, disengagement will, does have negative impacts on workers and communities sometimes. So it's important to make sure that you're using your purchasing power, your market power to, for positive things, and not just for, to punish, let's say.
Sure. I see that Ben, you put your hand up. Do you want to say something on that?
Yeah, maybe to add and focus much more on the monitoring side, because in my intervention, I focused, of course, on the enforcement of the Bangladesh Accord. But what I didn't mention is that, of course, the Accord was also manned by a whole, I think at a given moment, 200 competent engineers that inspected factories for fire and building safety risks, and so who are effective monitors of the agreement and the eventual implementation of the agreement. And then behind that, there was also a database where then 200,000 specific issues, like there's a staircase missing here, there's a fire alarm missing there, etc., were identified, kept, and also their status, in what extent they were successfully addressed, were also monitored. So there was such a granular amount of data available, which is also very crucial when you think about and later the enforcement. You need to have A, correct data, which is often a problem in the current industry of social auditors, and B, have all that data also together. And I think then maybe again coming to the EU Commission proposal, this is actually one of the weaknesses, that if you are looking at the enforcement strategies, how it is designed, public enforcement as well as civil liability, the dynamic in civil liability is that a worker or a community needs to step to a judge and say this company has not done its due diligence, etc. But it does not have necessarily all the access to the information, and it is not helped in the proposal to deal with that. The proposal doesn't address this. It does not give, for example, the obligation to the company to provide the data that the company has. And so it's all nice to think about enforcement and sanctions, etc., but the crucial element to get to that stage is data and insight and reliability. And the Accord has that. Electronics Watch also does that. It's also the core business to support that. And that's something that we need to factor in one way or another.
Gemma, did you want to say something on that?
Yeah, no, I'd back all of that up completely. The norms are still being developed, but there are clearly some out there which have been discussed today that can be pulled together and improved upon. And the issue around, I just would want to go back to the point of joined up government. The issue around the capacity development in the mostly producing countries is that, and in the richer countries, is that there are not enough labor inspectors, for example. Why not? Why is the money not invested in that when it's such a crucial, has such crucial consequences for lifting people out of poverty and out of danger? And the same, that point about information and access to information is so important. When Kathleen talked about how hard it was to do audits during the pandemic, had that information flow been properly capacitated at all levels that need to be capacitated, then the information, it's not that the information is not out there, it is out there. It's just about political will to make sure that the institutions and that the funding is properly backed up to make this happen. Without that, it's just, we're just all banging our heads against a brick wall.
Okay, I should probably wrap this up now. Unfortunately, I know that there's a few more questions here, and I apologize that we're not getting to all the questions. I do encourage anybody who wants to engage in further conversation to contact either the panelists directly. If you don't know how to do that, or if you'd like to just talk to somebody at Electronics Watch, we encourage you to, or Fair Trade Advocacy Office or IndustriALL. We certainly encourage you to contact our organizations directly as well to pursue this conversation. So with that, I want to also remind you that this session has been recorded. and that we will post the recording on our website, electronicswatch.org, in short time, so that you have access to it there and you can share it with others who you think may want to see it. And I want to provide a very heartfelt thank you to all the wonderful panelists today for your insight and for your deep commitment to due diligence and due diligence in public procurement, which is such an important development today. So thank you so much to all the panelists for the work you do and for participating today, and thank you so much to everybody who joined us today. And I hope that you will want to join us for the next session as well in this series, and that will be on the 29th of April, again between 2 and 3:30 Central European time. And this session will focus on the really critical part of remedy, which is often seen as the weak link in due diligence. So the right to effective remedy is the critical topic at the next session. Thank you so much, everybody, and thank you again for joining us.